Everything.
So do we have any like upcoming with him? You and
Um,
him?
Yes, it's
That case?
it's the, yeah, thefts with crop top.
The girl who I had to keep telling, don't come to
Come
court
here,
dressed like that?
yes.
Okay, gotcha. It's fine. All right, one for Judge Holmes. Make sure it's going to off or vibrate. There's clipboard in the side, make sure.
It's just the criminal thing.
This and clipboard. If you don't have one, let me know before you guys start talking, because it's gonna go over a lot of information.
I mean,
All
math.
right, well, me.
I mean,
She said they were having meth and these amphetamines for breakfast. She explained why it wasn't.
that's one step up from Woody's.
I know. It's definitely a problem.
I don't know, it's not. And there's a few back there. All rise. County Court Law number 2 is now in session. Honorable Judge Terrence presiding.
You may be seated. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. This morning, you have been asked to come to court for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious, it just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 2 years, a minimum of 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum of 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. And if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. Person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because, as I mentioned to you earlier, your offense is a misdemeanor case. And misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, the class C misdemeanors are cases that normally start in the city court or the JP court. They come to this court when a person gets convicted in one of those courts, and then they appeal the case, then the case comes here. Now, the punishment range does not change. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is fine only. The fine cannot exceed $500. So it's anywhere from $0 to $500, or $1 to $500. Now, however, if a person fails to pay the fine, or if the fine was converted to community service and they fail to perform the community service, then the court, the judge that is, can issue what is called a capias pro fine. What a capias pro fine is, it simply means that it's a warrant for the rest of the person to either pay the fine, or they would have to sit the fine out in jail, and it will be credited at $100 per day for every day that they sit out in jail. Okay, now, the next highest misdemeanor is a Class B misdemeanor. With a Class B misdemeanor, if a person is convicted, the range of punishment is minimum 0 days to maximum 180 days, or you could be given a fine from $0 to $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. Now, the first right that I'm going to talk to you about is your right to have an attorney. The clipboard that you have in your hand. Now, make sure that everyone that's here for arraignment, do you have a clipboard? Who do not have a clipboard is here for arraignment? Okay. Everyone has a clipboard. Now, on the clipboard, the first document that you see is titled Judge's Explanation of Rights to Defendants Without an Attorney. I'm going to go over this document with you. Everyone will sign this document. Okay? Now, in this document, it states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you want an attorney, but you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Number 3, you may represent yourself. That is, if you waive or give up the right to have an attorney, you have a right to represent yourself. Now, the first paragraph states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date different from the day's date to give you time to hire an attorney. Next paragraph states that if you want an attorney, but you can't afford to hire an attorney, you may request that an attorney be appointed to represent you. But you must first sign a document that is titled, it's a financial questionnaire. The document that is called the financial questionnaire is on that clipboard. It's a 3-page document. It is titled Jefferson County Affidavit of Indigence. Okay? You have to, and I have it here, you have to fill out the first page of this document. And then when you go to the second page, where it says defendant's oath at the top, you'll read and sign this, and then you'll sign in the middle portion that says unsworn declaration of defendant, and then you'll stop. Now, you fill out this document so that the proper person can determine whether or not you qualify for an appointment of a court-appointed attorney. If you would like to waive your right to have an attorney, that is, give up your right to have an attorney, you would like to represent yourself, you will have an opportunity to talk to one of the 3 prosecutors that are here in court today. They are assistant criminal district attorneys that work for Judge Giblin, P. Giblin, who is our district attorney. You will have an opportunity to talk to them to work out your case. And the reason why, because you'll be representing yourself, you'll be acting as your own lawyer, just like the lawyer will be able to talk to him. If you had a lawyer, if you represent yourself, you, your own lawyer, you would have an opportunity to talk to them. Now, you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of this document, in bold letters, it states defendant's choice, marking issues next to only one choice. So, if you would like to hire your own attorney, you will place your initials on the first line to the left. Now, if you would like to apply for a court-appointed attorney, because you do not have enough money to hire an attorney, you will place your initials on the third line to the left. If you would like to waive your right to an attorney, that is, give up your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initially one of those lines that I just mentioned, then you will sign your name on the line where it says defendant, and you will date it today's date, February 11th of 2025. Now, for those individuals who, if you are waiving your right to have an attorney, if you initial the fifth line, then you would have to read and sign the next document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Now, did anyone have any questions? Any questions before we move on? Okay, now you're gonna have time to, I'm gonna give you time to fill out the remainder of those documents. Now, the next right that you have is your right to have a trial by jury. Where those young people are sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors to listen to all of the evidence, listen to all of the arguments. They were retired to deliberate in our jury room, and then they can either find you not guilty or guilty of your choice. You also have a right to waive, which means to give up your right to have a trial by jury. If you waive or give up your right to have a trial by jury, that means you will not be having a trial by jury. Your case will come before the court or before the judge in one of 3 ways. One way it can come before the court is by way of a trial. And somebody might be saying, well, how can it come before the judge by way of a trial if I waive my right to jury trial? Well, it can come before the judge by way of what we call a bench trial. Not a jury trial, a bench trial. A bench trial is a trial by a judge only. The judge will be the judge and the jury in the case. Now, the judge will listen to all of the evidence, listen to all of the arguments. The judge will apply the facts to the law, and then the judge will decide to find you whether the judge can either find you not guilty or guilty of your choice. Now, the other way that your case will come before the court is by way of a plea bargain. A plea bargain is where a person talks to the prosecutors, they come to an agreement to settle the case, we call that a plea bargain. If you can't come to an agreement, but you still want to go before the judge, we call that an unagreed plea bargain. So if you have a plea bargain agreement with the state, the case comes before the judge can do one of two things. The judge could accept or reject your plea bargain agreement. Now, if the judge rejects the agreement that you've made with the state, you have a right to take your plea back. And when I use the term plea, what I'm talking about is a person can either plead guilty or no contest. That's on a plea. Now, you also have a right to plead not guilty. But if you plead guilty and no contest, you have a right, if the court does not follow the plea bargain agreement, you can take your plea back. And guilty means when you say I'm pleading guilty, you're telling the court that I committed the offense that I've been charged with. If you plead a no contest, you're telling the court that I'm not fighting the charges. Okay? That's what it means. And when you say you're not guilty, you're saying I did not commit the offense that I've been charged with. All right. So if you enter a plea of guilty and no contest, and you have an agreement with the state, it comes before the judge can accept or reject it. If the judge rejects, you can take your plea back. Now, if the judge follows the plea bargain agreement, and within, say, 30 days, you would like to, you say, well, you know what, I think I've been wrongfully convicted or the court committed an error by convicting me, I'd like to appeal my case. And appeal basically means you want to have a higher court to look at your case to see whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you. Now, if you want to appeal your case, if the judge follows the plea bargain agreement, you have to get permission from the judge to appeal your case. If the judge gives you permission, then your case is going to leave this court and go right upstairs to the Ninth Court of Appeal. There are 4 judges up there. They will review your case to see whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you. They can do one of two things. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals located in Austin, Texas, which is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you represent yourself. You don't have an attorney representing you, represent you pro se, you represent yourself. And you're asking them, or you're asking the court, or you petition the Court of Criminal Appeals to review your case, to see whether or not your conviction, your appeal should have been granted, or whether or not you were wrongfully convicted, or whether or not this court committed an error by convicting you. They can do one of two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down here with orders, order enough to give you a whole new trial. Now, if they deny your petition, then at that point, your conviction will stand. Okay. Now, I also said you had a right, if you could not come to an agreement with the state with your plea bargain, and you want your case, you still want to go forward, but you want the judge to assess punishment, we call that an unagreed plea bargain agreement. And the judge is going to just look at the facts of the case and review the evidence, background. It's a lot of punishment evidence that the court has to review, and then the court will decide what the punishment will be in the case within the punishment range. Now, you also have a right to have witnesses to come to court, because you have a right to call witnesses in your case. That area over there where that chair is sitting behind the microphone, we call that the witness stand. And what witnesses do, they can come to court, they can testify for you or against you. If you're representing yourself, you can ask them questions, or if you have an attorney, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to call witnesses, which means that you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have what we call a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify. I know a lot of times we look at television shows like Law and Order, and the police officer may walk up to somebody and want to ask them questions. They say, well, I'll take the fifth. Or if they're on the witness stand, we say, I'll take the fifth. What that means is they're exercising or invoking their Fifth Amendment right against self-incrimination. The Fifth Amendment is the United States Constitution. You have a right to remain silent. The state, the government, the DA's office can't force you to testify if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive it, which means you can give it up. And if you give it up, that means you will be testifying in your case. But if you do not waive it, you can't be forced to give it up. All right. Now, you also have a right to have what we call discovery. It just simply means that you have a right to see what's in the state's file. You have a right to see the evidence that the state has against you, okay? You have a right to discover the evidence or see the evidence that the state has against you. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, photos, audio, you listen to audio recordings. You have access to instruments or any type of documents that they have that they will be using in your case. Now, you also have a right to waive, which means to waive discovery, which means you have a right to give up your right to have discovery. Now, everyone that's here for arraignment, you're here, you first of all, charges was filed on you. A warrant was issued. You were arrested. You bonded out of jail. You're either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a personal recognizance bond or a PR bond, which means that you did not have to pay anything to get out of jail. You were just released under your own personal recognizance with a promise to appear here in court today. Now, I've said that to say this. Every day that you spent in jail can be used as credit toward your punishment. Remember, I said every day. Let's say you were arrested at you were booked in the jail at 11:59 p.m. last night. And you got out of jail at 12:01 a.m. this morning, 2 minutes later. That's 2 days. It's 2 different days, even though it's 2 minutes, but it's 2 different days. Okay? And so every day that you spent in jail, you receive credit for that time. Now, I said that to say this. Let's say you spent 5 days in jail. Let's say you talked to the prosecutor. They're offering you to serve 5 days in jail. Well, you wouldn't have to serve any more time in jail because you've already served 5 days in jail. Therefore, you will be given credit for the time that you have already served. Now, if the state is offering you 7 days in jail and you only spent 5 days in jail, that means you will only have to spend 2 days in jail because we will subtract the 5 from the 7 and that leaves 2. Now, every day, now let's say you're in the state of talking to the state, say, well, we're going to offer you fine and court costs. Okay. Now, every day that you spent in jail, you are credited at $100 per day. So if the state is offering you fine and court costs of $500, you spent 5 days in jail, which is $500. You will not have to pay anything. Why? Because you spent 5 days in jail. That's $500, so it will be taxed and retired. You won't have to pay anything. Now, if the state is offering fine and court costs of $700, you spend 5 days in jail, which is $500. You will only have to pay $200. Why? Because we will subtract the $500 credit that you received from the $700, and that leaves $200. Now, you'll be required to pay the fine and court costs on the day that you dispose of the case. If you cannot pay it, no problem. Because the law allows the court to allow you to be placed on what is called a payment plan, where you could pay in small monthly installments until the balance is paid in full. Now, some individuals may not have the income to pay it, even if we put you on a payment plan, no problem. Because the law also allows the court to convert your fine and court costs to what we call community service. Community service basically means that you'll be working in a nonprofit organization, a local nonprofit organization. Now, every 1 hour of community service that you perform, you will be credited $12.50 towards your fine and court costs. So, if you work 1 day, 8 hours, that's $100. You work 2 days, 8 hours, that's $200. So you can work 2 8-hour days and the $200 will be paid off. Okay. Now, Jefferson County has a program. If you've never been in trouble before, it's your first time getting in trouble. Jefferson County, when I say Jefferson County, I'm talking about the district attorney. They have a program that is called pretrial diversion. And what will happen is they will dismiss your case. You get in the program, they'll dismiss your case. And if you complete the program, you can get it wiped off your record. Okay? Let's say your record looks like this, right? This is your record. This is, somebody gonna check your record looks like this. But you're in pretrial diversion, you can be pretrial diversion, you can get what is called an expulsion, which means it's wiped off, deleted, or erased your record. So now your record looks like this. Okay? It's not there. Okay? So in order to qualify for the pretrial diversion program, it has to be your first time getting in trouble. Cannot be an offense involving unlawful carrying a weapon or resisting arrest. And you have to have an attorney to assist you with the application process to get into the program. That's it. Get into the program, they dismiss the case, you complete the program, you can get it expunged, wiped off, and deleted from the record. If you're interested in that, just let us know.
Right.
And we could direct you to the person that you need to talk to, or your attorney would know who to talk to get into the program. All right. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has a program that is called Veterans Court. It's a program for veterans only. And with that program, you get into the program, complete the program, they will dismiss your case. And you can get what is called a non-disclosure. Non-disclosure means that we cannot, or the government, we cannot disclose it or tell the general public that you were on probation, deferred probation for this case. And so anyone from the general public will go, the record will be sealed to the general public. Can't get in. Now notice I said general public. Now the government can have access. But most of the public is the general public, like Mobile Oil and some of these other companies that's not government companies. They can't get in it because the record is sealed. All right. Now, this court, County Court at Law Number 2, has a program that God led me to start in March of 2017. The program is called the Community Safety Initiative, the CSI program. Now that program is designed to address the issue of what we call recidivism. And recidivism just simply means people committing crimes over and over. And the way we address the issue of recidivism is through partnerships that we have in the community. Now, we have partnerships with, local agencies. One of the agencies that we have a partnership with is Philotop Center. Philotop is our local mental health center in the Southeast Texas, region. We'll have some individuals from Philotop that's gonna come before us today and tell you more about the program, but basically what Philotop, they have the expertise to address mental health issues. Now, when I use the term mental health issue, you do not have to be incompetent or insane. You can just merely suffer from depression or anxiety or any other host of mental illnesses. And Philotop have the expertise to address your issue. Now, what Philotop will do, first of all, they will conduct a private interview, either in our jury room, at their facilities, or by telephone, whichever is convenient for you. Then they can develop, they will have what we call an assessment. They will do an assessment to determine what the mental illness may be. And then they can develop a treatment plan to address the mental illness. Philotop also has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery program to address issues that individuals may have with drugs and alcohol. That is uncommon. It's not uncommon for individuals that have what we call a co-occurring disorder, which means an issue with mental health problems and an alcohol or drug problem. That's not uncommon. So with those two programs, the OSAR and the ATAR program, they will conduct a private screening, do an assessment, and develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed or looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school or you do not have a GED, well, CICE also have a GED program where you could receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2, we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community. Why? Because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned, just let us know when we call you for it, and we'll be happy to direct you to the right people to get you involved in any of the programs that I just mentioned. And so I just mentioned to you earlier that we have some individuals from Philotop, and they're going to come right now and tell you more about the program that we have. We have Caitlin and we have Deputy Hitt. They'll tell you more about the program that Philotop has on.
Thank you, Your Honor.
You're welcome. We got 400 on this. We need to get rid of one of those. He's got 400.
Okay.
Yeah, we're going back. One.
Yeah. Good morning, Myron. Okay, he might need the boy right there. Yeah. Oh, okay.
Oh, I think.
Good morning. As the judge was saying, my name is Steve Henn. I'm a mental health deputy licensed by the state commissions here with the sheriff's department. This is my coworker, Caitlin. Caitlin is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes to a bench. What the judge has found was statistics prove is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation. Now, maybe this is your first time to be in court, it could be your fifth time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us. And Caitlin's gonna explain exactly how you can do that very privately.
In the paper that I just passed out to all of you, at the top, it's name, birthday, phone number, and email. We need all these things to be able to put you in our system. And then under that is how would you like to be contacted? And it's call, text, or email. However you check the box is how I will contact you. Whichever box you don't check is not how I will contact you. So if you check call, I'll call you. If you don't, then I won't call you. I'll text you or email. Under that is what I need help with, and we have a lot of options. Most of them are just resources that we can send to you through email or through text. But if you would like mental health, and like I said earlier, that's depression, anxiety, PTSD, then we can get you into services and we can help you with whatever you have going on. And if you check substance use, like Jeff said earlier as well, that's one of our programs, and they can do drugs or alcohol, and we can also get you into that program if it's going to talk as well. And then everything else is pretty much self-explanatory, and if you want to talk in person today, you can just write, please talk to me today, and after the judge calls you up, I'll bring you to a back room and we can talk. Or if you want me to call you today, then write, please call today, or if you don't care, we're not contacting you this week, then just check the box.
So what we're all about is resource connections. And the first one we can provide for you today is this business card I have. It has a 1-800 number on here. If you ever find yourself in an unsafe place, you can call this number and get help immediately. Now, the court's going to go into recess here very shortly, and when it does, we'll be able to come out there. We'll visit with you. I'm going to hand this to everyone who wants one. We'll pick up those other documents from you, and we'll answer any questions you may have. If you want to talk, we'll work around the court. We're not here to prolong your court stay or interrupt the court in any way. We are here to work around it and see what we can do to best get you connected to resources that would best fit your particular situation. Thank you. Thank you, Your Honor.
Thank you, Deputy Hinton and Kate. Okay, ladies and gentlemen, as Deputy Hinton mentioned to you, we're gonna be taking a recess in a few minutes. The reason why we're taking a recess, one is to give you time to finish filling out the application. And then two, once the applications are finished, then we're going to call you up before the bench, one at a time, and we'll put you into one of three categories. These are what one category we want to hire an attorney. Another category, you want to see if you qualify for court-appointed attorney. Or the other category, you may want to represent yourself. Now, this is going to take us a little time to pick up the paperwork. If you need to use the restroom, the restroom right outside of the courtroom in the hall. The women's restroom is in front of county court at London. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. And the men's restroom is in front of county court at London 3. So if you need to use the restroom, you can go use the restroom. Now, do not leave the courthouse. If you leave the courthouse and your name is called and you're not here, your bond will be forfeited, warrant will be issued for your arrest, you'll be arrested, and then you're gonna come back and we have to go through this process all over again. Okay. So, again, now, if you need help filling the paperwork out, we have our court personnel who's here, who will be happy to help you. I'll be assisting as well. With Anyone who needs help with filling the paperwork out, if you need help, when going to recess, just simply raise your right hand, just simply raise your hand, and they'll come out and help. Okay? So at this time, we'll be in recess.
If you can, just complete your paperwork before you step out. You get to go to the restroom, like now, go ahead and go, but if you don't.
Well, waiting for.
Mr. Boykin, your full name is James Eugene Boykin.
Yes, sir, that's correct.
Mr. Boykin, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes,
Mr. Boykin, you may put your hand out. How are you doing, Mr. Boykin?
good, how you doing?
I'm doing fine, thanks for asking. Now, Mr. Boykin, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for, that state you like to have your case reset to hire your own attorney? Now, Mr. Boykin, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Boykin, I read your answers. Mr. Boykin, have a seat in that first chair. The court coordinator is going to reset your case. Once your case is reset, you'll be free to go and you have a blessed day.
Yes, sir.
Rena Morgan. Miss Morgan, your full name is Raina Morgan?
Yes.
How are you doing, Miss Morgan? I'm doing fine, thanks. Miss Morgan, would you please raise your right hand? Miss Morgan, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Morgan, you may put your hand down. Miss Morgan, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to hire your own attorney? Ms. Morgan, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Ms. Morgan, I read your answers. Our court coordinator is going to reset your case. Once your case is reset, you will be free to go. And you have a blessed day. Please have a seat in that second chair on the wall. Travis Baptiste. Mr. Baptiste, your full name is Travis Baptiste?
Yes.
Mr. Baptiste, would you please raise your right hand? Mr. Baptiste, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Baptiste, you may put your hand out. How are you doing, Mr. Baptiste?
Good, how are you?
I'm doing fine, thanks for asking. Mr. Baptiste, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to have your case reset to hire your own attorney?
Yes.
Now, Mr. Baptiste, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in this document true and correct
Yes, sir.
to the best of your knowledge? Okay, Mr. Baptiste, your case is going to be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to reset your case and give you your reset. Now, before she does that, I need to give you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over these bond conditions with you. And the document is titled Standard Bond Conditions in County Court at Law Number 2, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition 3 and 4 does not apply in your case. Let's see. Condition number. Oh, you have 2 cases. Yeah. Hold on a minute. Okay, now, condition number 5 does apply in your cases. And condition number 5 states the defendant shall attend AANA meetings 2 times a week and provide proof to the court. Do you understand that condition?
Yes.
Okay, I'm going to, now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, now, Mr. Baptiste, the bailiff is going to hand you 2 documents. First document is offender AANA verification sheet, and the second document is a list of locations of AANA meetings in Jefferson County. Okay, now on the verification sheet, every time that you come into court, well, every time that you go to AANA meetings, which is 2 times a week, you need to get a sponsor at the meetings to sign that form. And when you come back to court, you need to bring that form with you so you can verify that you are attending AANA meetings. Do you understand? All right, and there's a list of locations in the Jefferson County area that you can go to a AANA meeting. All right, just have a seat in that first chair and wait for your name to be called. Mandy Antley. Mr. Antley, your full name is Mandy Antley?
Yes.
Mr. Antley, would you please raise your right hand? Ms. Antley, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Antley, you may put your hand down. How are you doing, Ms. Antley? Are you doing all right? That's good. Now, Ms. Antley, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Did I sign that? Last guy. I did. Okay. Okay, Ms. Antley, I have before me 2 documents. Well, 1 document. The document is titled Judge's Explanation of Rights to Defendants Without Attorney. Did I swear you in? Can you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. Now, Ms. Antley, this document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
It is.
Are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign and initial this document, did you read the document?
I did.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Antley, your case is going to be reset to give you an opportunity to hire your attorney. Our court coordinator is going to give you a reset. Once you get your reset, you're free to go. And now, before she does that, I need to give you some bond conditions. The bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you, and it states as follows. Following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply because it's only applied in a DWI case. Your case is not a DWI case. However, condition number 5 does apply. And condition, that's on the next page. Condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Ms. Antley, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Ms. Antley, you can have a seat in that first chair, wait for your name to be called. Once your name is called, you go to the window. Once you finish at the window, you're free to go, and you have a blessed day.
Thank you.
Ryan Iverson. Mr. Iverson, your full name is Ryan Iverson. Ryan Edward Iverson?
Yes.
Mr. Iverson, would you please raise your right hand? Mr. Iverson, do you swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Iverson, you may put your hand down. How are you doing, Mr. Iverson?
Very well. How
I'm doing fine, thanks for asking. Mr. Iverson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Iverson, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Iverson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat on the second chair on the wall. Daniel Briggs. Mr. Briggs, your full name is Daniel J. Briggs.
Yes, sir.
Mr. Briggs, would you please raise your right hand? Mr. Briggs, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Briggs, you may put your hand down. How are you doing, Mr. Briggs? I'm doing fine, thanks for asking. Mr. Briggs, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Briggs, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Sir.
And is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge? Mr. Briggs, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall. Xavier Ingram. Mr. Ingram, Your full name is Xavier Ingram.
Yes, sir.
Mr. Ingram, would you please raise your right hand? Mr. Ingram, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Mr. Ingram, you may put your hand down. How are you doing, Mr. Ingram?
I'm doing good, sir. How about you?
I'm doing fine, thanks for asking. Mr. Ingram, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney? Another document that's titled Jefferson County Affidavit of Indigence. And do you recognize this document?
Yes, sir.
On page 2 of this same document. Okay, you forgot to put his last name on this, sir. Yeah. Okay, now, Mr. Ingram. Is this your signature on the second page above the line that's titled Defender Signature? Mr. Ingram, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Ingram, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you, in this case, Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in the first chair on the wall. Regina Garcia. Ms. Garcia, your full name is Regina Marisol Garcia. Ms. Garcia, would you please raise your right hand? Ms. Garcia, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Garcia, you may put your hand down. How are you doing, Ms. Garcia? No, fine, thanks for asking. Ms. Garcia, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Ms. Garcia, before you signed and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Garcia read your answers. Based on your answers, you meet the eligibility requirements of the Department of Court-appointed Attorney. And the attorney that will be appointed to represent you is Attorney Jennifer DeLodge. Attorney DeLodge will give information to contact you. You will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that third chair on the wall. Emily McCullincheck. Did I pronounce your last name right?
It's Mickelinchuk.
Mickelincheck?
Yes, sir.
Mickelincheck, okay.
Y'all are fine.
Oh, the U is silent.
Yeah.
Mickelincheck, okay. Ms. Mickelincheck, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Mickelincheck, you may put your hand down. How are you doing?
How are you?
I'm blessed as well. Thanks for asking. Now, Ms. Mickelincheck, I have before me two documents. First document is titled, the first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Mr. Mickelchek. I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Ms. Mickelchek, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yeah.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Mickelchek, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. I mean, the second chair on the wall. Joshua Elliott. Mr. Elliott. Mr. Elliott, your full name is Joshua Brian Elliott.
Yes, sir.
Mr. Elliott, would you please raise your right hand? Mr. Elliott, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Elliott, you may put your hand down. How are you doing, Mr. Elliott? That's good. And Mr. Elliott, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. Elliott, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Do you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Elliott, I read your answers. Based on your answers, I was unable to determine whether or not you meet the eligibility requirements for the appointment of attorney. And what I need to do, I need to ask you some questions. Put this on mute. Now, this is cause number 24 CCCR 2936. Case is styled the state of Texas versus Julian Alexander White. Mr. White, is that your full name?
Yes, sir.
Mr. White, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. White?
I'm doing good. So,
I'm doing fine. Now, Mr. White, I have before me two documents. The first document is titled Judge's Explanation of Right to Defendants Without Attorney. You recognize this document?
yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. White, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. White, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in the second chair on the wall. Here's the clipboard. You're gonna get you.
Oh, right. I'm sorry.
I didn't do mechanical. That is what my insurance and my fuel is.
Okay, let's do this, Mr. Elliott. Showing your document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this document, is this your signature?
Yes, sir.
You've previously been sworn in. Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Okay, Mr. Elliott, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Laurie Perazzo. Attorney Perazzo will be given information to contact you. And you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that third chair on the wall. Yeah, you can sit right there. That's fine. Yeah. You have any food, Freddie? Jacob Kozad,
I believe it's pronounced Kozad.
Kozad. Okay, the court is in session and calls numbers M327440 and calls number M327444. Both cases are styled the state of Texas versus Jacob Kozad. Mr. Kozad, is that your full name?
Yes, sir.
Mr. Kozad, would you please raise your right hand? Mr. Kozad, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Kozad, you may put your hand down. Mr. Kozad, well, first of all, Mr. Kozad, how are you doing?
Doing good, how are you?
I'm doing fine, thanks for asking. Mr. Kozad, you're representing your case by your attorney, James Macon. Attorney Macon, how are you doing?
Getting through the day,
Well, that's good.
always good.
Every time. Let's see. Now, Mr. Macon, do you waive a record in Mr. Kozad's case?
Yes, Sean.
Mr. Kozad, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. And in this information, Mr. Kozad, it alleges that you, Jacob Kozad, on or about August 12th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, transportation. Mr. Kozad, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Cozad, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading,
Guilty. Yeah, guilty.
are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Cozad, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Mr. Cozad, do you recognize this document?
Yes, sir.
On page 2 of this same document, there's two sets of initials. One set is your attorney initials, the other set is, assume is your initials. Did you place your initials on this document?
Yes, sir.
And on page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, it is.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. This document is on paper. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, it is.
Mr. Cozad, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
Yes, it did.
And did you read and understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes.
Mr. Cozad, are you a citizen of the United States?
Yes, sir.
State offer states 1.
Any objections?
No objection, Your Honor.
No objections. State's Exhibit number 1 will be admitted. Mr. Maker, you advised and counseled Mr. Cozad. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Cozad, your attorney, Mr. Macon, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, it has.
Mr. Cozad, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 365 days in the Jefferson County Jail, credit for 365 days, tax and retire all court costs, and dismissal of the companion case.
Okay, Mr. Cozad, the state is offering that you serve 365 days in the Jefferson County Jail. However, you will not be required to serve any more time in jail on this case because you've already served 365 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That means you will not have to pay court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Cozad, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes.
And Mr. Cozad, also the state will be dismissing the companion case, is that correct?
Yes, Your Honor.
Cause number M327444. Mr. Cozad, do you accept the state's offer?
Yes, I do.
Okay, Mr. Cozad, I'll follow the plea bargain agreement that you have made with the state. Mr. Cozad, this will conclude this case. Mr. Cozad, you will stand next to the bailiff, follow her direction. Once you finish following her direction, you can follow the bailiff. And you have a blessed day. And Mr. Macon, you're free to go, and you have a blessed day.
I'm gonna go.
Your Honor, when we approach Gabrielle Smith,
Yeah, okay, hold.
If you need me, call me, I'll come back and get you.
Okay.
Your Honor,
Yeah, hold on a minute, let me pull it up. Gabrielle, okay, hold on, let me get the crossing. Did you get Gabrielle Smith? Female, huh?
it's a female.
Gabrielle,
still be showing 252nd.
Your Honor, what's transpired today is they had her set for sentencing. And in speaking with Mr. Hubel, that case has now been reset for
First.
three.
Yeah, to March 11th for a status hearing, Your Honor.
So I would just ask that we be reset with a felony.
what is it, MTRP or something?
No,
no,
they
it's-
only have the same offense.
I don't need her over here.
No. I would not.
So you said a status hearing,
So it would seem that the plea didn't go through.
oh, so, okay. So we just have to reset it on the same day,
That's correct, Your Honor, with the court's permission.
okay. Yeah, we have to reset that on the same day. Okay,
What date, 3/11, Andrew?
That's right. Oh, okay, they have in the notes what happened. The judge actually rejected the plea.
okay, so it's back at square one and we rejected the plea.
Okay. See you on the 11th.
So we're leaving.
Thank you, Judge.
They're on the same day, yeah, 11th.
Work the 11th.
Okay,
That's what I was hanging around for.
okay, yeah, you received an appointment too today.
That's what I was saying to go. Yeah, yeah, I'll get it now.
Okay.
Oh, wait on it, I'm already here.
Let me have that Nikia Jackson.
Hmm? Jefferson County Court Law number 2 is back in session. Court is in session. Two cases, cause numbers 24 CCCR 2982, cause number 24 CCCR 2984. Both cases are styled the state of Texas versus Nikhil Latrell Jackson. Nikhil Jackson was scheduled to be in court this morning at 9 a.m. on the court's arraignment docket on today's date of February 11th, 2025. At or about 9 a.m., the court's bailiff called Nikhil Jackson's name at the courthouse door. Nikhil Jackson did not answer. Nikhil Jackson has not appeared in court since the court has been in session. Now, the court did receive information that she may be in the hospital. Is that her?
No.
No, that's not her. Okay, well, strike that. Now, Ms. Bailiff, would you please call the name of Nikhil Jackson at the courthouse door?
Yes. Okay. Number contact.
Nikhil Jackson's name was just called again at the courthouse door. Nikhil Jackson did not answer. Nikhil, a reasonable time has passed to give Ms. Jackson an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Statements for bond forfeiture.
Nikhil Jackson bonds will be forfeited in each case. And of course, grants the motion, and the warrant will be issued for Nikhil Jackson and cause numbers 24 CCCR 2982 and cause number 24 CCCR 2984. And this, well, we still have one more case on the court's docket. We'll be in recess. This will conclude the calling of the court's arraignment docket on today's date, February 11th, 2025, in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you're excused.
Thank you, Judge.
You're welcome.